Good evening, everyone, and welcome to tonight's FDU Alumni webinar series sponsored by the FDU Alumni Association and the Office of Alumni Relations. Tonight's topic is Estate Planning for Your Family, featuring Shirley Whitenack and Regina Spielberg from Skank Price Smith & King, LLP. I want to take a moment to let everyone know some tips for your best webinar viewing experience. We are recording this evening's webinar, just to let everybody know, so we do have it available to view afterwards. We have also muted all participants upon entry. In order to best hear our presenters, we ask that you remain on mute throughout the presentation. We will have a Q&A session at the end of our presentation, and many of you submitted questions at the time of registration. You may also choose to submit questions at any time tonight via the chat feature on Zoom. You can find that by highlighting your mouse over the bottom and you'll see an icon for chat, and you can type in a question either directly to me or to the whole group. And I will share as many questions as we can during the Q&A portion, but please note we might not get to all as time may or may not permit. Thank you, everybody. And at this time, I'd like to welcome Kenneth Lamb, the Executive Director of Alumni Relations and Development at FDU.
Thank you, Jennifer. Good evening, everyone. Thank you for joining us tonight for an important conversation on planning for our family's financial future. We're fortunate tonight to have with us two experienced attorneys from Skank Price Smith & King. First, tonight we have Regina Spielberg, a partner at Skank Price Smith & King. She joined the firm in 2005 and currently co-chairs the Estate, Gift, and Charitable Planning Practice Group. Certified as an elder law attorney, Regina assists seniors, people with disabilities, and their families on legal matters involving elder care, special needs planning, and planning for incapacity. She focuses on promoting the best quality of life for the individual. Regina was also invited to join the Council of Advanced Practitioners of the National Academy of Elder Law Attorneys, a group of highly experienced elder law and special needs planning attorneys. We also have tonight with us Shirley Berger Whitenack, also a partner from Skank Price Smith & King. Shirley joined the law firm in 1999 and is co-chair of the Elder and Special Needs Law Practice Group and the Estates and Trust Litigation Practice Group at Skank Price Smith & King. Shirley is also a mediator and is past president of the National Academy of Elder Law Attorneys, a fellow and a member of the Academy's Council of Advanced Practitioners. She has also been an adjunct professor of law in the JD and LLM in elder law programs at Stetson University College of Law. Shirley and Regina, thank you so much for being with us tonight, and I look forward to your discussion.
Thank you, Ken. I'm going to start out tonight, and Shirley will follow with some other conversations after I have talked about some of our initial estate planning topics. So I want to thank everybody for joining us tonight. It is an honor to be here with the FDU alumni. And thank you for sharing some of your evening with us. It's kind of nice that you can do this in your fuzzy slippers if you want. We're going to talk about estate planning tonight. And we've already received some questions. So I want to start out by saying that estate planning is more than just a last will and testament. A good estate plan should address your goals both during lifetime and after your death. So it's important that we talk about both lifetime planning, which is what Shirley will be addressing, and after death planning. So a number of you have asked questions about last will and testament, and I just want to talk a little bit about what a last will and testament is, what it can do, what it cannot do. A last will and testament, most of you already know, is the document that allows you to determine who gets your assets after death. But the question becomes, what assets does a will pass on? A will only governs, only controls the assets that are probate assets, or the assets that are in your individual name. So assets that have a joint owner, joint tenancy on a checkbook, for example, or a house, or assets that have a beneficiary designations like an IRA, a 401k, life insurance, or assets at a bank account that maybe are on transfer on death TOD or a POD account, those are not probate assets. Those assets are not going to pass under your will. And it's important for you to understand that. We need to, as part of an estate plan, we need to coordinate both probate assets. So again, the assets that pass under your will are only the assets in your individual name, and non-probate assets, which are the assets that do not pass under your will. And frankly, people coming into my office these days have such a significant amount of non-probate assets, particularly retirement benefit assets, that in some cases it's greater than the assets passing under their will. So a good estate plan is going to help you have appropriate beneficiary designations on those assets. Or we might tell you to separate your joint accounts. We might tell you to split accounts between spouses, or take a child off of a pay on death bank account because you don't want to disproportionately benefit one child, or maybe you do want to disproportionately benefit that child, and that is a way for you to do it without it being reflected in your will, which all of the other beneficiaries are going to see. And you should know a will is a public document. You can go and ask for a will for anybody. We can ask the surrogate, which is where the wills are probated on your death, for a will for anyone at all. As a matter of fact, I have a copy of Babe Ruth's will. So they're public documents. And as a result, sometimes people want to do a trust, but we'll talk about trusts a little bit later. So what does a will do? In a will, you're going to choose the person or persons who will administer your estate. They're called the executor. You don't have to have one executor. You can have more than one. They can be co-executors. We always encourage people to have successor executors, because you need to understand, when we do an estate plan, planners are going to look beyond what your snapshot looks like today. So we're going to ask you, for every role that you choose an executor, there should be at least one successor executor, because you don't know if at the time in the future when the will is going to be needed, that person will be alive or able to serve as your executor, or even willing to serve. Nobody can be made to serve. So we have at least one successor executor named. When you're choosing who is going to get your estate, and I'm going to pick a kind of common plan. Let's say we have two spouses and they have children. We'll start there with what we'll call a typical family, even though there really are no typical families, and we learn that every day in our office. Many people will say, I want to leave everything to my spouse, and if my spouse predeceases me, to my children. That's fine. But what I'm going to say to them is, what happens if, God forbid, one of your children predeceases you? Do you want their share to go down to their children? What if they don't have children? What if they don't have children yet? What if their children are minors? What if they're 2 years old or 3 years old? So then we need to talk about, do you want your estate or part of your estate to go to such a young child? We may need to put a trust into the will document itself. That's called a testamentary trust, to cover those eventualities. In case somebody who's young is going to be a beneficiary under my will, I want the money to be held for them and used for their benefit. In that case, you will need to name a trustee in your will. And again, we're going to push you to appoint or name a successor trustee, just in case at the time that the trust may be needed, that the first named person is not going to be able to serve, you have a backup. Okay, so now we have talked about, if I have all my assets going to my spouse, and if my spouse predeceases me, to my children, fine. What if it's a second marriage? What happens if we have two people who've been married before and they each have their own children? Maybe I don't want my estate to go to my spouse's child or children. I want my spouse to be able to benefit from my estate, but I want it to go to my children. Or maybe you do want it to go to your spouse's children. Maybe you want to share things equally. So these are conversations that we need to have. And it's so often the case that someone will call me or come to a meeting and say, I don't have a lot of assets. I really just need a simple will. That is not a conversation that we can have before we have a lot of information. Okay? You can't know that you need a simple will until we go over the facts, your circumstances, your family situation, whether you have a second marriage, whether you have children by another person, whether you have a child with special needs, in which case we would most likely want to do a special needs trust for that child, whether you have a taxable estate. So in New Jersey, the good news is that we no longer have an estate tax. It was done away with in the beginning of 2018. However, we still have an inheritance tax. The inheritance tax in New Jersey is based on the relationship between the decedent, the person who died, and the beneficiary. And the relationships are divided into classifications. So we have a Class A beneficiary. There is no tax on Class A beneficiaries. Class A beneficiaries are a spouse or descendants or your ancestors. So your parents and your grandparents, your children, your grandchildren, your great-grandchildren, your whole line of descendancy, and your spouse. There is no Class B. There is a Class C, which is a taxable classification. That is your siblings and your siblings-in-law. And that Class C is taxed beginning at an 11% rate, but the first $20,000 can pass to them tax-free. So if you're leaving $20,000 to a sibling, that's fine. There should not be a tax. But if you're leaving a share of your estate to a sibling, there's likely to be a tax. And the taxable estate is not only your probate estate, it's also your non-probate estate. So your taxable estate includes all of your assets. And I should mention that if you do not have a will in place at the time that you pass, and any of your assets are in individual name, then your assets will pass under our intestacy laws. Every state has intestacy laws, and ours in New Jersey are like most states, where if you have a spouse, then it all goes to the spouse unless there are children by another person, whether if your children are not all common. So if you have children by previous relationship and you have a spouse, then all of your estate is not going to your spouse. It's going to be divided between your spouse and your children. That is not necessarily what most people want. Most people want to be able to choose how their estate passes. Now we're talking about New Jersey law for the most part here, and the concepts that we're talking about are generally similar in the other states, but wills and probate are governed by state law. So if you're out of state, you would need to talk to an attorney who is licensed to practice law in your state. And every state is different with regard to its probate, and that becomes important when we talk about how to do the planning. As an example, I'm admitted in New York, and in New York, the process for probating a will, probating the will is the process by which you present a will, or your will is presented for you to the surrogate, the county surrogate, who determines whether it's a valid will. That is the probate process. If that will is determined to be valid, then whoever is the designated executor will be issued some authority from the surrogate that they can go forth into the world and present their authority to third parties like banks to put together your assets and handle your estate. If if I have a client in New York, I will tell them up front, the process for probating a will in New York is much more time consuming than it is in New Jersey. New Jersey has a simplified probate process. You don't even need an attorney to probate a will in New Jersey. And the cost of probating a will is based on the number of pages in the will. Whereas in New York, it's based on the value of the estate, so it can become much more costly than it is in New Jersey. And they have a lot more paperwork to fill out in New York. So in order to avoid some of those costs and some of those complexities in New York, I would likely recommend that the client have a revocable living trust that would have the dispositive terms, the substantive terms of the disposition of the estate in the trust. We would also have a will, but the will would say any assets in my probate estate will be distributed to my trustee of the revocable living trust. Now, there may also be reasons in New Jersey to do a revocable living trust. We may have a person who doesn't have close family and they are concerned about management of their assets should they go forward and lose some of their abilities, and they maybe don't even want to manage their assets anymore. In that case, we might recommend a revocable living trust. Sometimes it can, I'm working in an estate now where I prepared a revocable living trust and a pour over will for a New Jersey resident. And she was concerned that her family, she had no children, her husband predeceased her, and she was concerned that her family might try to influence her. There was some dementia in her family, and try to influence her. And so we set up a revocable living trust for her and transferred much of her assets to the trust during her lifetime. She remained her own trustee until her death. But if she had lost her abilities, then we had a successor trustee lined up who could take over for her seamlessly. So, and that can work very nicely. Another reason to have a revocable living trust, which is pretty common, is if you have real property out of state. We have a lot of clients who have either a country house upstate New York or they have a Florida condo. And by having those out-of-state real properties in a revocable living trust and doing that during your lifetime, you avoid having to probate your will in the second state. So your will always gets probated in the state where you are domiciled, which is really your state of residence. And if you have real property in another state, then the will has to be probated in that state unless you put it into a revocable living trust or unless it's in joint name and it passes by to the joint owner. So that's another reason in New Jersey to do a revocable living trust. Oh, I didn't finish. So I just want to jump back to the inheritance tax. I didn't say the last classification of beneficiaries is Class D, and that is everybody who's not a Class A or a Class C beneficiary, every individual. And that can be the neighbor down the street, a niece or a nephew, or a stranger. They're all the same Class D, and they start the taxation at 15%. So another reason that you should have a will is you can say that all of my inheritance taxes get paid out of my residuary estate, which is the balance of your estate that's left after your executor pays your bills. And if you don't do that, or if you don't have a will and your estate passes by intestacy, then the tax is apportioned and each beneficiary pays the tax based on what the assets are that they're getting. I will tell you that may sound not problematic, but I am working on an intestacy estate right now, and there was significant assets passing to a Class D beneficiary that really was an IRA, and I and we're having trouble getting the IRA beneficiary to pay their share of the inheritance tax, which by law they're supposed to do. We might have to go to court to force that payment. So you can avoid these types of things by a good estate plan. I think that maybe I'll turn it over to Shirley now. I didn't leave you very much time, Shirley, but you go ahead. Shirley's going to talk about the documents that we use in an estate plan for lifetime planning. And you can use a trust this way as well. But Shirley's going to talk about very important documents we call ancillary documents.
Thank you, Gina. So I want to talk about documents that we prepare when we're doing wills and/or trusts. We typically also talk to our clients about planning for incapacity. The fact of the matter is, if you do a Google search on whether there is a greater risk of becoming disabled versus death, you will find pop-ups from all kinds of disability insurance carriers that are going to tell you that you have a greater chance of becoming disabled than dying at certain ages. Where they're pulling these numbers from, I'm not exactly sure, but the Social Security Administration has also done a very similar study. And the one that they did in February of 2020 basically says that if you are 20 years old, you have a 25% chance of becoming disabled before you are now eligible for regular Social Security, whatever that age is, 66, 67, it all depends on what year you were born, that the chances of men dying is a little higher than women, but they basically said you have a 25% chance of becoming disabled and about a 16% chance of dying. So we also know with COVID now that there are issues of people who were healthy that are now sick, that are now in ventilators for a month, for 6 weeks or longer. So while wills and trusts are extremely important, so are documents that will allow somebody else to manage your assets or manage your health if you are not able to do so by yourself. There is also a myth that if you are married, that your spouse automatically gets to manage your money if you can't do that anymore. And that is not the way that it works. What you need is a general durable power of attorney. A general durable power of attorney is it's a fairly simple document where basically you are appointing someone else to engage in financial transactions for you, typically when you can't do it yourself. So for example, when you have an IRA or a 401k, only the owner has control over those assets unless somebody has a power of attorney. Your spouse cannot withdraw money from your IRA. So if you become disabled and you are at an age where you have to take required minimum distributions and it's not automatic, then nobody is going to be able to do that for you. Or for example, you own a house, you own it jointly, and you are in the process of maybe selling the house and you become disabled. Your spouse will not be able to finish that transaction on your behalf if you are not able to sign those documents unless that spouse has a power of attorney. Powers of attorney can also designate the powers that they can have. So for example, can the agent make gifts of your assets? Well, only if that power in New Jersey, that power of attorney document must actually specify the power of the agent to make those kinds of gifts. Otherwise, they can't do it. Why would you want your agent to make those gifts? It may be because you are planning, possibly, um, for being in an assisted living facility or being in a nursing home. It may be to reduce taxes if you live in a state where there is an estate tax. You might want to do that kind of planning, or you may have a pattern of giving, maybe to your church or to your synagogue, maybe to your children, and you want those kinds of gifts to continue. So in that document, the power of attorney, you name an agent, you name a successor, you want to name somebody that you trust who can manage your assets in the event that you are not able to do that yourself. Certainly, even if you execute a general durable power of attorney, if you are able to engage in your own financial transactions, you'll continue to do that. It comes into play primarily if you can't do that. Now, there is a different type of financial power of attorney. It's called a springing power of attorney. That is a document that only comes into effect if an event that is stated in that power of attorney is triggered. So, for example, that power of attorney may say that it only comes into effect if two doctors state in writing that you are incapacitated. Or it may say that one doctor certifies that you are incapacitated. We don't like springing powers of attorney. Why? Because when that triggering event happens, many people deny that that happens. Number one. Number two, you're going to have to demonstrate to the financial institution that that event has been triggered. Do you really need Bank of America to know that you were declared incapacitated by your doctor? And moreover, if you don't trust someone enough to give them power of attorney when you're competent, how can you trust that person when you're not competent anymore? So we recommend general durable powers of attorney to engage in financial transactions. Whether you give it to the agent or not is up to you. It will also have other powers, for example, the power to go into a safe deposit box if you have that, the power, as I said before, to sell real estate, the power to engage in stock transactions for you, to withdraw money, to pay your bills, to deposit money into your account, to basically do those things that you could do. Different states have different requirements for their powers of attorney. All of these documents, by the way, the wills, the trusts, the powers of attorney, all have ways that they must be executed to be valid. The state laws tell you how many witnesses you need, whether the documents need to be notarized, and the probate clerks in every single state look very, very carefully to make sure that all of these documents have been executed properly. If you are executing a power of attorney and you bring it to a bank and it hasn't been done correctly under the law, they are going to reject that document. So you want to make sure that it's done correctly. You want to make sure that the document says everything that you want it to say. Another important document besides those are healthcare proxies or medical powers of attorney. So just like appointing an agent to engage in financial transactions for you if you are incapacitated, you can designate an agent to make medical decisions for you if you are not able to do that yourself. So, for example, you are in a car accident and you are unconscious, or you have a stroke, or you are under a ventilator because you contracted COVID. Someone else will be able to make medical decisions for you if you have executed a healthcare proxy where you have designated an agent to make those kinds of decisions for you. Now, I mentioned before that if you have a general durable power of attorney, that agent can engage in financial transactions for you, even if you are competent and able to do that yourself. Under New Jersey law, a healthcare proxy is only effective if you are not able to make medical decisions for yourself. So in essence, in New Jersey, a healthcare power of attorney is really a springing one, because doctors are going to have to certify that you are not capable of making those decisions for yourself. Just as with all the other documents, we recommend that you name successor agents. It doesn't have to be the same person that you've designated as an agent under a power of attorney or an executor in a will or a trustee in a trust. If you have a family member who maybe is a healthcare provider, a nurse, a physician's assistant, a doctor, you may want to name that person. You may be concerned about decisions that somebody may or may not make. So these decisions have to be carefully determined by you. You know your family members better than anybody else, or your friends, in choosing the person that you want to make these kinds of decisions for you. And a third document that is very important in planning is what is known as a living will or an advance directive. Most states have statutes dealing with living wills right now. So a living will is essentially a document where you, in essence, have written instructions for what you want to have happen to you if you are dying. You are in the stages of dying. You have been designated as having, for example, a terminal disease that is expected to last for less than 6 months. You're in a persistent vegetative condition with no prospect of recovery, according to the doctors. You're in an irreversible coma with no prospect of getting better. And under those circumstances, a living will can be implemented in the state of New Jersey. So that document would state, for example, whether you want to have, under those circumstances, you want to have artificial nutrition or a feeding tube, whether you want to have artificial hydration, intravenous fluids, whether you want to be under a ventilator if there is no prospect of recovery. So you can actually specify what happens if you are in that condition. So many of you may remember that a number of years ago, there was a famous case in Florida regarding a woman by the name of Terry Shivo. She was a young woman in her early 30s. She was married and she had small children. She had executed a healthcare power of attorney, but she did not execute a living will. She had named her husband as her agent under the healthcare proxy. And sure enough, she became very, very ill and she was unconscious. And so a fight ensued between her husband and her parents as to whether she wanted what it was that she wanted if she was in this condition, because she had not executed a living will. Her husband said, I had these conversations with my wife, and I know that she would have not wanted to have these measures taken if there was no prospect of recovery. Her parents disagreed. And so they went to court and they fought on this. By this time, by the way, her husband and Ms. Shivo had been divorced. He had been remarried, and they were still fighting over what to do about her condition and spending a lot of money doing that. And these issues are they common? No, but they do happen. They happen more frequently than we would like to know. So these are important documents to have. You can have a combination living will and healthcare proxy, or you can have that as separate documents. You can even have a psychiatric healthcare proxy where for people who may suffer from bipolar disorder or other kinds of mental health issues can dictate what to happens if they are having an episode or not. So these documents are very, very important for people to have at any age. And typically, I have many clients whose children have gone on to college. They're over the age of 18. So their parents no longer have the ability to manage their child's money or to make medical decisions for them if something happens. So they have us draft these documents for their college age children. Very, very important documents to have as well. Gina?
Okay, I'm unmuted, sorry. Agreed with everything Shirley said, and I was sneaking a peek, Jennifer, at our questions. I wonder if we could address those guardianship questions.
Absolutely. We did have a couple questions on the topic of guardianship. Let me just get a second here to scroll through where those were. I did have one that came in via chat, actually.
Oh, there are two in the chat.
Yeah. So the first one was, can I include custody arrangements for my son in my will if custody is currently 50-50%?
And would you read a couple down? There's another guardianship question. I think we should answer them together.
And the other one is, can you create a guardianship without a will?
Okay, so in your last will and testament, you can and should name a guardian if you have a minor child, or if you have a child or a person that you are serving as guardian for who is an adult, who is an incapacitated adult. And that's important because it's important that a parent or a guardian express who they believe would be the best guardian for a minor or an incapacitated person during their lifetime, because you're not going to be there to say it later on. Now, if you have a custody or a settlement agreement in a divorce, a custody agreement, that is going to govern over your will, most likely, unless there are intervening circumstances. I imagine that they could be contested, but in general, a last will and testament is only going to name the person you want to be guardian if the other parent is not going to be serving as the child's guardian, because Shirley can really address this better than I can, but a parent is a natural guardian as opposed to a legal guardian. Is that correct, Shirley?
Yes.
With
Under
regard,
the age of 18.
Under the age of 18.
Or a child who has special needs. That is not emancipated.
Okay. So can you create a guardianship without a will? Yes, we do it all the time. If there is someone who is incapacitated, you would do a guardianship, but we typically are doing those guardianships for people who are over the age of 18. So we may do guardianships for adult children with special needs who really do not have the capacity to manage themselves once they become adults. And the natural guardian is no longer natural guardian after somebody reaches the age of 18. So we go to court for those people. And also for seniors, we very often are going to court for seniors, parents, for parents who lose their capacity, or anyone else who loses their capacity, whether it's in an accident or an injury of some kind. Shirley?
Well, so here's the thing. I talked before about having a healthcare proxy and a power of attorney. But what I didn't talk about is what happens if you don't have those documents and then you become incapacitated. So a person who is diagnosed with neurocognitive disorder, major neurocognitive disorder is the new term now for senile dementia. If a person has Alzheimer's or that, and they did not execute a power of attorney and a healthcare proxy that, by the way, cost a few $100s, you are now looking to go to court and spending a few $1,000s to obtain guardianship so that somebody can make decisions, financial, medical, residential, educational, vocational decisions for that person who can no longer manage their own affairs. It becomes very, very expensive because there are many documents that need to be filed with the court. Financial documents, documents from doctors that say that this person is incapacitated. And so it is always preferable to have a power of attorney and a healthcare proxy than have a situation where they have no documents and now you have to go to court and spend several $1,000s to get that same result.
Not to mention that you could have other family members who contest the guardianship and there could be a fight ensuing. Whereas you could have made your decision known in a document and avoided that.
So you want to name in your wills, if you have minor children or you have a child with special needs, you will want to name a guardian, successor guardian for those children until they reach the age of 18. At the age of 18, the law presumes that all individuals are competent. So you can run your child's life, if they are typical children, up until age 18. But then they get to do their own thing and they get to make their own decisions. So guardianships, unless there is a child with special needs, that will end at the age of 18. So those are the guardianship questions. Jennifer, what are some other questions?
Sure. Another question we had is, I mean, I think it's similar to guardianship, so we'll just like kind of tie this one in, but how do I keep my estate in my bloodline only?
Well, that's what we would express in your will. That's exactly what the will would say. So I would say, you would say something like, to my children, and if one of my children predeceases me and they leave children, it would go to their children. But if they leave no children, I want it to go to, my descendants. And it's very straightforward to do that. We do that routinely, and in the same fashion, we can make provisions if something is dropping down to the next generation or two to have trust so that we don't have to lodge any of the money with the surrogate, which might have to happen if you don't have a properly executed will. So if you have no will and your assets pass by intestacy and they end up passing to a minor child, then money has to get lodged with the surrogate. So we can write up pretty much any estate distribution scheme that you can come up with, and keeping things in the bloodline is fairly typical of what my clients look for.
Great.
We had a couple of good questions in chat about.
There are. I have another one from the chat right now.
Go ahead.
So if 90% of your assets are non-probate, such as the 401k, is a will even necessary?
Nobody just has an IRA. Everybody owns something.
Even if it's just a car.
It could be a car. It could be furniture. It could be clothing. It could be jewelry.
It could be an
tangible personal property.
An income tax refund.
It can be anything.
It can be the refund from the nursing home.
So somewhere along the line, somebody is going to have some assets that are not going to be in their 401k. And so if you die, who gets all of those other assets? That is really the question in this case. And so that is why you want, if you just have 401k, you still want to have a will to designate what happens and who gets all the other assets. Because if you do not do that, then the intestacy statute that Gina spoke about before kicks in, and the state is going to tell you who is going to get your stuff. So we do have a provision in the state of New Jersey where you can have a list of, for example, tangible personal property that you may want to give to specific individuals. You can write that list, you sign that list, and it can have the same force and effect as if you actually had it in your will, so that anytime you want to change it, you can do that. It doesn't have to be notarized. You don't have to go to a lawyer to do that. But everybody has assets that are not in their 401k. I promise you.
And by the way, the list that Shirley mentions has to be referenced in your will. So if you don't have a will, your list is not effective. It's not legally effective. So yes, everybody does have assets that are probate assets. And you're just going to make things easier for your family if you have a will.
One other thing that I don't recall, and Gina, correct me if you said this already, but one of the key issues between having a will and not having a will is that typically when you have a will, the will is going to say that the executor does not have to post a bond, does not have to buy an insurance policy that protects the estate from having the executor take the money and run off to Rio de Janeiro or wherever. But when you have an intestate estate, in most cases, the court is going to require that administrator, whoever is applying to manage that estate, to post a bond, which can be expensive depending on the size of the estate. You may not even qualify for a bond depending on your own financial condition. So that's another good reason why you want to have a will.
And the payment of the bond, of course, comes out of the estate. So it's another expense you can avoid by having a will.
Thank you. So another great question that came up in chat was, you guys had mentioned that joint assets need not be included in the will, but where would you specify what would happen with those assets if both die, say, in an accident?
So that's an interesting question, because then we have to ask who died first. And do they have a will? And if they don't have a will, is the intestate estate the same for both of them? Do they have common children? So let's say you have a common accident and you have children by a previous marriage. And let's say your spouse survives you by more than 5 days. And that's the law in New Jersey. So if your spouse survives you, and they will inherit your estate unless you have something else written up, and they can dispose of the estate however they want. If you don't have a will, they will inherit by intestacy, and then the money will go to their family. Now, if you have all common children, it may not matter. If you have minor children, again, you have the problem of, do you want an 8-year-old to inherit a share of your estate? So yeah, so I worked at a firm during 9/11 where a young couple were both working together and were both killed in the towers. And of course, there was a lot of money came out of the compensation fund, and there was a fight between the families. I mean, there was no presumption. There had to be a settlement. They were trying to say one survived the other, and there was no way to prove that. So there was a settlement, but it can really result in some bad feelings and not maybe the results that you would have preferred if you did a little planning in advance.
Great, thank you. Another question that just popped up was, how do you disinherit a family member in your will?
That comes up more often than you would realize. And frankly, you can leave your estate to whoever you want. You don't have to leave it to, except for your spouse. You do have to make a provision for your spouse. And if you don't make a provision for your spouse, the spouse may have a right to go to court and make a claim for a spousal share under certain conditions. However, if you want to disinherit somebody, you specify in the will that you want to disinherit them, that it's your intention to leave this person out of your will and they should get no part of your estate. When that happens, I always ask, are you just mad at that person? Do they have children? Do you want their share to go to their children? And sometimes, sometimes it's the child who's disappeared and they haven't seen them for 20 years. And sometimes it's a bad acting child and they're still happy with the grandchildren. So it's something that we explore. Like I said, estate planning is not just a will. We have to explore all the facts and circumstances, but you can absolutely put into your will, I do not want this child, or I don't want Shirley to inherit any of my estate.
Hey,
It doesn't mean that the person's not going to cause some trouble and contest the will. We can't prevent that. We can just put what your intentions are into the will and be your best advocate in testifying and saying, we had that conversation and they did not want the person in the will and they knew what they were doing when they signed their will. And generally that will govern. Is that correct, Shirley?
yes.
A lot of people want to put in what's called a no contest clause into a will. And a no contest clause, or sometimes called an interim clause, says that anyone who contests a will, who's a beneficiary of this will and contests the will receive no benefit from the will, from the estate. And in New Jersey, those are likely not to be enforceable if the person has any reasonable claim to make. That the no contest clause is not going to be enforced in New Jersey. That may not be true in every state.
And you have to be careful when you're trying to disinherit somebody for two other reasons. Number one, if you're going to put a reason in the will of why you're going to be disinheriting this person,
Don't ever do that.
Don't
Don't ever
do
do
that,
that.
because then you can have a fight ensue as to whether those underlying facts were true or not. You don't have to give a reason why you are disinheriting someone. The second thing that I want to also point out is that sometimes when you're disinheriting someone, as Gina said, even if you have a no contest clause, in this great country, anybody can file a lawsuit on anything, anywhere, anytime. We have learned that in this, past period of time, that happens all the time. We live in a very litigious society right now. So if somebody can find a lawyer or even do it themselves and they want to bring suit, they can do that. Well, one of the ways that you can avoid that is by leaving somebody something so that they have to decide, is it worth contesting? Am I going to lose that as well? Sometimes that no contest clause should be in there because the person doesn't really know whether it's going to be effective or not. In New Jersey, it may not, a no contest clause may not have the same teeth as, for example, California, where it's more likely to be enforceable. And we live in a very mobile society as well. So you can disinherit somebody, but the language that you're going to use is a discussion that we're going to have. And we're going to have a talk about what are the chances of them contesting? How savvy are they? Are they going to have the assets to hire an attorney and fight this? Why don't you want to give them the assets? We want to make sure that people aren't being unduly influenced, by the way, especially if they're elderly.
Great.
Next question.
So much information I kind of like soak in, right? And there's so many great questions being submitted. Another one that we had was, and we were talking before about, your assets. Is it best to transfer all assets to a trust for a child in order to avoid taxation?
Well, I don't know anybody wants to give away all their assets to a trust for a child. So right now we have a federal estate tax that permits you to give a combination of lifetime gifts and passing your estate at death. With no estate tax, you can give away $11.58 million this year. Each person. So if you have a married couple, you don't have a tax, there is no taxable estate until you pass $23 million. And that has really taken most people out of the taxable estate for federal purposes. We do not have an estate tax in New Jersey. There is an estate tax in New York, and the exemption for each person is just under $6 million. You can also give as much of your assets away during life or on death to your spouse with no estate tax, either federally or in New York. Most states have an unlimited marital deduction for assets that are left to a spouse. So most of my clients are, when they hear that they can pass that much of their assets on without a tax, and if they have Class A beneficiaries, there's no inheritance tax, they're not usually willing to give up control of their assets to pass it into a trust for a child. Where we would run into that more, or maybe recommend a little bit more, and I would never recommend that any client of mine give away all of their assets and leave themselves unable to pay for their own care and maintaining themselves. But we would maybe divide the assets and put them in trust if we were doing some elder law planning, but that's a separate topic, okay? And maybe we'll come back and talk about that at one point, but I don't think we would be giving away all our assets in order to reduce our taxable estate. If you do have a taxable estate, or if you're concerned about the federal estate tax law changing, which it may very well under the new administration, we do have ways of reducing the tax so that, and some of it may involve gifting. So those are other things that we would talk about in estate planning.
Great. And we do have time for just one more question. And we did have a question in the chat, which is very similar to many of the questions we also had submitted ahead of time. And I think it's the perfect question for wrapping up this evening. And I do have to, before I ask the question, recommend the two wonderful attorneys we have here presenting tonight. But what is the best way to find a good estate attorney?
So the best way to find a good estate attorney is really word of mouth. If you know someone who has had a good result and likes their attorney and can make a recommendation to you, that is a great thing to do, or another family member. You want to make sure, however, that that attorney that you're going to is experienced in doing estate work, is experienced in wills and trusts. Look, law is like any other specialty. Do you want your ophthalmologist to remove your appendix? Do you want an environmental law attorney or a criminal attorney to write your will? Can we do this legally? Sure, we can. Just as your ophthalmologist can take out your appendix. But that doesn't mean that you want them to do that, because they are not experienced in doing that. Maybe they did it as a resident, but they've been an ophthalmologist for 20 years. Same with attorneys. You want to go to an attorney that has experience in doing estate work, that you have no idea, none whatsoever, how many wills cross our desk that were, or trusts that were done, or powers of attorney, or healthcare proxies that were done by other lawyers that are defective for all different kinds of reasons.
Shirley, tell them what your saying is about LegalZoom.
So LegalZoom is a document assembly program that you can buy online. You want to buy a will for $50, you go on LegalZoom. I call it the gift that keeps on giving to attorneys, because we have to fix these documents constantly, because those documents are only as good as the information that you are providing. And if you have anything going on that is a little bit out of the ordinary, could be the ages of your children, it could be whether you're in a second marriage. If these documents are not done precisely the way they are supposed to be, they are not going to do you any good. And we find ourselves having to fix these documents, having to do do-overs. So now you've paid me, but you've also paid for that LegalZoom program or wherever you went before. So don't look at price as your main reason to have this done, and don't assume that anybody can do what you think is a simple will, because there are very few of us. You got to be 18 years old with no money to really have a simple will. Am I right? I mean, everybody's got something going on in their lives, somebody that you don't want to necessarily have inherit your assets. You want it in your bloodline or what have you. So if you don't have that word of mouth, what else can you do? You can go to your local bar or county or state bar. They have references that you can look at for people who have signed up and want to do this. You can go to look for estate planning attorneys online, certainly, and we do get clients who visit our website and read our bios and decide that they want to do that. If you need an attorney, you can also ask an attorney that you know, can you recommend an estate planning attorney? If that is not there in their wheelhouse, you can ask them for recommendations. I often get asked if I can recommend estate planning attorneys in Connecticut, California, Wyoming, Colorado. You name that state, I will find you an estate planning attorney. Email me, I dare you, I will find you somebody. So they're there and they're around, and you can read their bios, you can ask questions, you can see if they have certain certifications. We don't have an estate planning certification per se in New Jersey, but you get that person. Don't look in the yellow pages. I don't even think they print yellow pages anymore. It's not the best way to do it. But ask around and you will find somebody. But don't be governed by price alone. That's not to say, you know, pay $10,000 for a simple will, but also don't look for the cheapest will possible, because you do get what you pay for.
Thank you. Thank you so much. And I do have to share with our audience that estate planning is what you both do. And I think you've done a great job tonight. And certainly, if you're looking for someone to work on those things for you, Shirley and Regina would be a great place to start. I do want to say thank you so much to you both for tonight's webinar for our alumni and sharing your expertise in estate planning. It was a lot of information. I hope everybody, we got to as many questions as we could. I know we couldn't get to any. We couldn't get to all of them. So we hope we were able to round up as many of the topics in those questions as we could.
Jeff, thank you for the thumbs up.
Thank you.
And I do want to thank everybody for attending tonight as well. So thank you for attending tonight's webinar. Please keep an eye out for a follow-up email with an evaluation. We'd love to get your feedback on what you think of tonight's webinar. And please be sure to visit support.fdu.edu to find out about our upcoming events, news, and information for our alumni and friends. Thank you all again for joining. Thank you, Shirley and Regina. And
Thank you, Jennifer.
You're welcome. And we hope everybody has a wonderful evening.
Thank you for having us.
Thank you. Take care.
Bye-bye, everyone.
Bye, everybody.